regard to expert reports after that, and the other dates remain the same. So now here we are with problems everywhere. And so what's the problem?
Good morning, Your Honor. Christine Garitano for the plaintiff. I appreciate you entertaining the parties on short notice on these issues. From the plaintiff's perspective, there are three main issues. There may be others that others have, but from the plaintiff's perspective, the issues that we have are threefold, all related to depositions that have been noticed and the scheduling of those depositions. The first relates to a notice of deposition for a representative of Defendant AECOM. That deposition was noticed in late December. Defendant's counsel indicated that it had some objections and asked for a meet and confer. We did do the meet and confer. As a result of the meet and confer, I attempted to address many, but not all of the issues raised by AECOM's counsel. I believe at that time we were still on an impasse at 9 of the 31 categories requested in that deposition notice. However, for the remainder, I did make some attempts based on our discussion to modify some of those. Amended notice of deposition was issued the following day. We received late yesterday new objections to the amended notice. I believe now the amended notice, by the way, eliminated a couple of categories, so there were 29 distinct topics.
Which 9 remained outstanding?
The 9 that remain outstanding are presently after the latest round of objections.
Well, before you tell me that, which 2 were eliminated from the original 31?
The 2 that were eliminated are all documents produced by AECOM, which was originally number 26. That's been eliminated entirely. And I'm sorry, I did a compare red line, so I'm looking at that. The last one originally was 31, which was AECOM's discovery responses. I eliminated those in their entirety.
Okay, so all but 9 have been agreed upon? Is that what you said earlier?
No, we were at an impasse at that point after the meet and confer, except with respect to 9 of those. After I revised and narrowed the scope of some of them, we are now at an impasse at apparently 12 of the 29 categories.
So you were at 9, you revised it, now you're at 12.
Well, to be fair, after the meet and confer, I revised them. He had to go back to his client to, consult with them.
Okay.
And after that, there were still some that they refused to produce witnesses on. So that's that initial issue.
Okay.
The second issue is I noticed a fact witness employee of Defendant AECOM, Vikram Gautam. He is a geotechnical engineer on the project based on discovery.
You say he was on the project. They say he was not on the project. He had nothing to do with the project.
Yeah. Well, Your Honor, I didn't know what that until they produced documents that imply or suggest that, in fact, he was specifically consulted about the use of the shale fill material when it was being proposed. Now, I understand, based on our meet and confer, that his intention is to say that he doesn't remember that. Well, that's fine if that's his answer, but I believe I'm entitled to cross-examine him on that.
Okay.
So that's with respect to the project. He was also consulted later when AECOM was investigating what the issue was. He was consulted at that time too. Again, the documents indicate that. So that's another issue I think I'm entitled to talk to him about. I believe I'm also entitled to talk to him about his general knowledge, understanding, experience, and expertise as a geotechnical engineer with respect to this use of this material in general.
If he was involved in the project?
Whether,
Or if one of those two factors, either when the problems arose initially, and you raised that to AECOM, if he then reviewed things, so is it one of those two hooks that he would be able to talk about that in general? Or just
Correct.
as a guy who knows this stuff, or
That's
may or may
right.
not know? Okay, is one of those two hooks, right?
that's right, Your Honor.
Okay.
It's plaintiff's position that AECOM sold this project to my client on using its vast knowledge and expertise in every specialty. And therefore, I think that we are entitled to explore, whether or not they did that. We know that actually they did, and what that knowledge and expertise was, and why they didn't use it in this case, apparently.
Okay.
So that is the second issue. The third issue is just the general order and scheduling of depositions. No one had noticed depositions in this case before I did so in December. I noticed those and requested that they be provided in a particular order based on plaintiff's strategy in this case. I believe I'm entitled to do that. Approximately a week later, defendant AECOM issued its own deposition notices, which is fine. I don't object to any of those, including the 30B5 categories that they gave me, which are very similar to the ones they're objecting to in mine, but my clients don't have anything to hide. But given this dispute with respect to these two issues, I don't believe they should be able to take the depositions that they requested of mine because they manufactured a discovery dispute, so they could go first. I think it's common practice, and if everybody's being honest, if you notice depositions first, you get your witnesses first. That's just the way it goes. And so, until we can, agree on the depositions that I've asked to take, I don't think I should have to produce my witnesses. Now, I did offer to schedule them all, including mine, in the order that I requested off of the bat, and then deal with these discovery disputes. And if we could get them resolved, we'd have them calendared and scheduled. Nobody seemed to want to do that, and so we were apparently at an impasse on that issue. From the plaintiff's perspective, those are the three issues with respect to discovery.
Go ahead.
Thank you, Your Honor. Dan Heyman for AECOM. Addressing the three issues, starting with the 30B notice, and we've presented, as requested by the court, our position in pretty good detail, generally into the specific requests. And I don't think it's accurate to say after we had our meet and confer, we were down to 9. We got a revised notice, and we did make some progress. Some there's agreed to be limited. We got the revised notice, I believe, last Thursday. As I told Christine, we would review and get back to her. She unilaterally said, here's the revised notice, we're now down to 9. But in any event, I think we're at about 13. But as we've indicated, Judge, first of all, this is the first deposition they want to take. Okay, so of a 30B, there's been no depositions, which is going to require us to educate someone on this project before the benefit of any depositions, including our former employees. All our employees on this project that happened 8 years ago are no longer with us. So, it's likely, instead of being able to point to their deposition testimony, we're now going to have to schedule meetings, et cetera. And some of these, as you've seen, just the sheer volume is impossible.
Hold on a minute. But, so you've indicated Stahl, Lachina, Renzel, and Harvey, right?
I'm sorry, Stahl, Lanchina.
Stahl, Lanchina, Christy Wenzel, and Brad Harvey.
That's correct. There's been no, and they're no longer with the company,
Right.
and there's been no request yet for Wenzel or Hartman. But we have been in contact with Stahl and Sheena. They work for other companies now. And as I explained to plaintiff's counsel last week, I can't in good conscience ask these people to call in and schedule time off of their current jobs on a tentative basis with no idea if this deposition's happening. We're prepared to present those people. But if plaintiff insists that we have to have a 30B5, assuming we can agree on some categories, that's going to take some time because we have an obligation to educate someone on this. And, you know, there's been, our client alone, I think, produced almost 500,000 pages of documents. We're getting close to 1 million pages of documents in this case. We're talking about incredible breadth, especially what they've asked for, and putting aside just the ones that are incredibly broad with respect to this project. We have 3 or 4 of the 12 that are in dispute. I have 13, but 12 or 13 that are in dispute that want us to put up a witness who has global knowledge of all the projects that AECOM has done, global knowledge, with respect to certain issues. And so that's just, I don't know how you'd even begin to do that. You know,
The issue relates to the fill, right?
Correct.
That's what we're talking about, the fill.
correct. There's fill on every project, Judge.
I know that.
So
The issue in this case, the main issue seems to be the fill.
Correct.
The shale.
correct.
Okay. So,
So if the, but how are we about to, you know, find out, you know, from the scope of what they're asking for? It could be a project in California, it could be a project in Beijing, it could be, and how do we even begin?
okay, let's quit playing around. Let's take out the list
Okay.
of 1 through 29 and go through it. What's the first one?
First one, Your Honor, is AECOM's knowledge, evaluation, and decision-making regarding the suitability, risks, recommendation, and use of pyritic shale spoil excavated from the Northeast Ohio Regional Sewer District project as engineered fill supporting interior building slabs of the YMCA School District and Senior Center.
Okay, go ahead.
We've agreed to produce a witness.
I'm
on
sorry,
that. It involves this project.
I'm trying to find your latest objection.
No, let's go, I'm looking at the original list of 31.
Okay.
Okay. That's what I have in front of you.
I just did the amendment.
Would you like, Your Honor, for me just to go over the ones that AECOM says they will not produce
Well, I'd like to
witnesses
see a
for?
copy of it, so I'm looking at it as you're,
Yeah,
all I
think
have
it-
is the original that was filed with these emails.
I think it would be helpful, Judge, if you have the amended notice
Judge,
and,
I do have a clean
I can-
copy of the amended.
Yeah, I do
Okay.
as well.
and do you have our responses? Would you like our
This
responses
is,
too?
this is our responses.
Okay.
So that's the, what Christine said is the amended and your responses?
Yeah, I
That's
have
correct, Your
the
Honor.
amended, yes,
That's the
yeah.
current status.
Okay. Thanks.
The court should have an electronic copy of this as well from our position that was submitted yesterday.
I did also, Your Honor, at Maria's request yesterday, provide her a red-lined version so you can see how they were changed from the first notice to the amended notice, and I can give you that if you think it's useful.
All right, well, number 1 on the amended list, there's an agreement.
Correct. So I will move, Your Honor, to number 2,
Okay.
which there is, AECOM has indicated in its latest objection that it cannot produce a witness. That is AECOM's knowledge and experience nationwide and globally with projects using shale or shale-containing materials as engineered fill regarding suitability, risks, recommendations, and use of shale or shale-containing materials as engineered fill for the project where AECOM has the noted knowledge and experience.
Okay.
And again, Your Honor, plaintiff's position is AECOM regularly markets and sells itself as a global leader with expertise in all of these areas. And in fact,
So what is it you're looking for?
I'm looking to know what they know and understand about using shale fill material on construction projects.
Judge, if I could put a little perspective on this. every building in Northeast Ohio's got shale in the fill. And if you look at the expert reports, it is a very detailed analysis, and we don't have to get into it now. But the notion that there's a green light, red light on shale fill is just nonsense. I mean, we'd all be living in tents in Ohio if that was the case. There's shale everywhere. So this is so broad. This, I don't know how many tens of thousands of projects, and how do we even begin to do that? And they're all different because they all have geotechnical.
Is it your position that shale shouldn't be used as the fill? And shouldn't have been used as the fill in this project?
That's right.
Okay. What does the contract say?
The contract has the specification for engineered fill, does not permit the use of clay, which shale is specified as is classified
So, do you have,
technical terms as.
so I presume you're going to have an expert that says that this was the improper fill to be used to take out whatever was excavated.
Yes, Your Honor. And his expert says that, and everybody's expert says that.
Okay, so
That's not the issue. The issue is I believe I'm entitled to tell the story to the jury about why AECOM, knowing and understanding, being the global leaders in construction that they are, decided to propose to my client to use this material that is plainly and commonly understood as to be improper underneath the building.
But it wasn't permitted to be used, is what you're saying, by contract and by all the experts, right?
That's right.
Okay,
Not our expert, Your Honor.
okay, well.
And but that is the issue. And so it has nothing to do with our global knowledge.
I know it's the issue.
It has nothing to do with our global knowledge. And they didn't, we may market ourselves that way, they didn't hire that services from us. We had no designer or engineer, we were the construction manager. They hired the architect, who, like every project, has a geotechnical engineer that they hired, who tested this specific material and told us it was okay. So is there an issue?
Or didn't test it and say it was okay, one or the other.
They absolutely tested it.
Okay, and they say you didn't test it.
No, we did it.
But anyway, see, we can sit here from now until the summertime when it's scheduled for trial and talk about this shit, but what I'm interested in knowing is getting the depositions done, because the expert reports were to be filed June 2nd, I think it was, okay? And the remaining by September. Now that's been moved, done. Fact discovery was done. But apparently,
Oh, Your Honor, I believe at the regional case management conference, due to the case, there was no fact discovery.
I know there was no,
Yeah.
I
Correct,
presume
that
I presume that
expert-
you wanted to do written discussion in advance of taking depositions.
That part was,
Okay, not depositions. So let's try to get off the ground and stop discussing, you know, I brought up the contract, so that, but I want to get the, so you think you should be able to have somebody who be that has knowledge of and all the representations they've made. They made the website.
they made it on their website, and they made
Okay.
it in the response to the
Okay.
request for proposal for this project, where they say, as a full-service
So
company.
so you believe that it's true that they hold themselves out as action?
That's right, Your Honor.
Okay.
I have no idea.
Who do they produce for something? How about the president of AECOM?
The president of AECOM is not gonna have knowledge of every,
Okay.
well, that's
I
what,
don't-
globally.
The
Listen,
United States.
Oh, great.
your point is, they hold themselves to construction, okay? And because shale was used, either pursuant to the contract, that's a bullshit claim that they made. Otherwise, all right, what's that really got to do with this? Isn't this a case of whether the use clay/shale, clay/shale? Isn't that the point?
Ultimately, but again, I think I'm entitled, and because I believe the facts are clear, including their geotechnical engineer that they consulted with, using this
Consulted with
material.
either during the project or after
During-
that Guyama, or whatever, that guy.
I believe, when I get to, they shouldn't have used this material. So, you know, the jury's going to question, Your Honor, why did they do that? And I think I'm entitled to tell the full story. And part of that story is that they didn't bother to either use their expertise that they promised us that they would use, and that I think is part of the standard of care that is an express provision in their contract, to use their expertise.
The contract either calls for them, allows them to use shale, clay, or not use shale, clay, right? The contract.
Your Honor, shale clay was not originally specified to be used. It came about as a change on the project due to the discovery of unsuitable soils during the site
Well,
work.
I mean, is it unusual to find unsuitable soils in site work?
It is not unusual, Your Honor, and therefore the contract included not the type of material to be used, but a unit price. So AECOM was only able to charge our client by contractual agreement before they knew that they had to bring in 10,000 plus cubic yards of this stuff, that they were only going to charge $25 a cubic yard. They were limited to that by contract. Their subcontractor apparently had this, and when it bid the project, bid very low for that unit price, which probably helped them win that contract. And so they had to use something that wasn't going to eat into their profit margins. And so they used this shale. And I want to tell the jury about how AECOM fully well knows that it shouldn't have been used, but they disregarded that because they just cared about making as much money as they could.
So it was not prohibited by the contract?
Your Honor, it was
Shale-
prohibited by their contract.
Okay, you told me the only restriction was the unit price of whatever had to be used as the fill.
No, Your Honor, the specifications have a general specification for the types of material that are acceptable and unacceptable by their general classification. By their general classification, the material is unacceptable. Nevertheless, the construction manager recommended it, and the architect and its geotechnical consultant approved it.
Okay, I'm not gonna let you, 2 is out. 3.
Okay, 3 is AECOM's knowledge, expertise nationwide and globally regarding the known risks and consequences of using expansive material as engineered fill, including but not limited to AECOM's knowledge and experience regarding when unsuitable fill material must be sent or rejected or sent to a landfill.
Similar objection, Your Honor. I don't know how we even begin to present a witness on that.
Who hired ATC?
The architect TDA, we did not hold that contract. And by the way, ATC is the one who, in real time, when the decision was made about using this fill, tested it twice and reported the results. TDA reported to us that it was acceptable. But I don't want to get into all the merits like we've been going. I want to focus on this, Your Honor.
So do I, but I had that question because you keep saying we weren't the geotechnical engineer.
They didn't hire us for
On the
geotechnical service. Sorry, Your Honor, that's correct, and our contract expressly says we are not responsible for the architect's scope, which included the geotechnical engineer. So we may market ourselves that way, and we certainly have that capability because it's a big company, but they didn't hire us for that. They hired us for what's in our contract, which is to be the construction manager.
So whose job was it to provide the geotechnical engineer so that the specs could be drawn and the contract fulfilled?
I'm sorry, it was the architect hired the geotechnical engineer, who, like any project, started with the geotechnical engineering report before design's even done, talks about what kind of fill can be used, et cetera. Then, of course, we get the specifications, which is what we're bound to. But none of that we didn't have anything to do with developing those specs. That was the design professional and their geotechnical engineer. Is there an issue of fact as to whether or not we met the spec? Yes, that's what this case is. It's that simple, Your Honor. And all this other stuff about telling our story wants to distract from what happened here and why.
So who was responsible for determining what fill went back in the hole?
Your Honor, the construction the entire construction and design team. So the construction manager was
Who had by contract, who had the approval? When decisions are to be made, such as this one, we're excavating however many cubic feet, what's going back in, whose job is it to approve or disapprove of that?
Your Honor, I believe it is both the architect's job and the construction manager's job.
That's what the contract says?
Yes, and the contract has a specific provision that says if the construction manager recommends a material or product that it warrants to the owner that that material is fit for the specific purpose.
Your Honor,
Your Honor, when there was a discussion about what fill to use, the architect did not propose shale or any other material. The construction manager proposed the shale material.
Okay. So going back to number one, that everybody agrees on.
correct.
Who's going to be produced for that?
I don't have a body here, but because it's limited to this project, we can educate someone. It's going to be someone who wasn't on the project, most likely, because there's none left. But we, as we can do and have an obligation to do under Rule 30b-5, we'll educate someone
Okay.
as best
So
we can
as
with
to
the
the-
records. We'll try to put them in touch with the people who are on the project if we can, but they don't want
As to the decision-making regarding the suitability,
It's all in the records, Judge, and we'll have someone that will have reviewed and educated themselves on the
okay,
records.
so somebody will have reviewed the suitability and the risks and the recommendation of the use of the shale?
That's correct, Your Honor, the spec section is very clear, by the way, when you have unsuitable soils, the architect, in consultation.
I don't care about that, okay?
Okay.
You're gonna produce somebody that answers her questions about the suitability of this shale being used as the fill, correct?
Everything in here, the knowledge, evaluation.
Right, I'm
decision.
just focusing on the
Okay,
shale.
Yes, Your Honor.
Okay? And so there's somebody that
Subject to this.
kind of infers to me there's somebody within AECOM that looked at the suitability of shale. Okay? And so she's gonna ask, well, what did you review? Who did you get this from? I got it from Joe Schmo.
That's correct,
She
Your
can
Honor.
go depose Joe Schmo.
You're correct, which is actually a third-party defendant, GLC, who was our site contractor. But, Your Honor, I mean, we did object to this, although we'll produce a witness, just to make it clear. We
I
didn't
thought we
make the
agreed on
decision.
number one.
We didn't make the decision, but we'll have someone who can talk about everyone who did and all the
I
records.
thought we agreed on number one.
Correct, Your Honor.
Okay. Then what are you objecting to?
Well, I'm sorry, I thought you were asking who we were gonna produce for number one.
I was asking that, okay, but whoever you produce for number one is going to be able to talk about the recommendation of and use of shale.
That was made by the architect, and it's.
I don't care who.
Okay, yes,
See,
yes,
so
Your
that's
Honor.
gonna point her in a
Yeah,
direction that
yes.
it was Joe Schmo, okay? And then she can go and depose that person, right?
Yes, Your Honor.
So what's the problem with that?
No problem with number one, Your Honor.
I know there's no problem with number one, but you want to talk about their knowledge of, in their representation that they know all this stuff.
Yep.
And part of what you're going to find out is their recommendation and use of shale. And that's going to point you in a direction of somebody at AECOM or within AECOM or who AECOM consulted that says shale's good for this. So why isn't that enough? Why doesn't that give you the same thing you want by the worldwide investigation here?
I think, again, Your Honor, I mean, If you believe the interpretation of that is broad enough to encompass that, then I'm fine with that.
That's what I believe.
Okay. And we're in agreement that I can ask about those matters within
Well,
the
they've
scope
already
of number
agreed that
one.
you can ask about those matters.
Number one.
Right.
Correct, Your Honor.
Okay.
Not number two, which is out, and there's similar ones after it. We're not gonna have a witness who's gonna talk about our experience in every project that ever used shale.
I just said that, we just
Okay.
covered that.
Okay, well, I think plaintiff's counsel said as long as I can do that on number one. I just want to be clear, Your Honor. Thank you.
Okay,
Okay.
Your Honor, so just to move this along, I'm gonna agree to remove 2, I'll remove 3. 5. Okay. Let's move on to a different issue. Number 6, AECOM's knowledge, understanding, compliance, performance, and breaches of the contract with the plaintiff for the project that is the subject of this lawsuit. AECOM has responded that it will only produce a witness who can authenticate the CM at-risk form executed by AECOM. And their knowledge and understanding of that is contained in the plain language. Somebody that says, yeah, this is the contract. But
That's
not
our-
talk about what they did, didn't do, should have done. And just by the way, Your Honor, they asked me almost the exact same question for my witness.
Which we discussed our meet and confer, and I said if you want to narrow it, we will. I've asked for a meet and confer on their 30B5 because both parties have an obligation to conduct one, and I haven't had it yet.
I don't have any objections.
Okay, well, good, thank you.
I thought I said that at the
We'll
beginning.
expect dates then for those witnesses. Your Honor, knowledge and understanding is in this contract is thousands of pages. It's a construction contract. Compliance, performance, and breaches, again, we're gonna put a witness who's gonna talk about everything we did that's documented in 500,000 pages of records? Or are we gonna focus on what's at issue, which is number one, which we've agreed to do? So it's not.
Well, part of what
It's-
their complaint is, when they brought the first heaving of concrete or cracking in the walls, they said, well, you guys are warranting this work, so come and look at it, and according to the plaintiff, you said, well, we don't know nothing about nothing, everything's good.
Not accurate, Your Honor. There were years of the parties, and well after this project was done, well after punch list, where we were involved. Architect was driving that ship, by the way, which you would expect, because it's a geotech issue. But nonetheless, there are other specific categories in here with particularity, like what did you do to investigate, that we're agreeing. You know, warranty claims, we're agreeing. But this general, give us someone who can talk about everything you did on the contract and all our allegations of breach, is again just not within reasonable particularity required by the rules. It's basically the whole case. Put someone up who can testify about anything I want to ask on this case.
If it's limited to the issues in this case, I don't know why I wouldn't be able to ask about those things. And I don't know why you wouldn't be able to produce a witness to do that. We all know what the issues in the case are. I'm not going to ask about some obscure section of the contract that doesn't have anything to do with this case, of which there are many. I think we all know what the
So
issues are.
you're
in
talking
the
about
case.
number 6 as it relates to the fill and building envelope issues?
Yes, Your Honor.
That's, again, number one is the fill, which we talked about. There are specific things, to your point on investigation, as we go through this, I can point to them. We agree to that. If you tell us particularly what you want, we have the ability to prepare a witness. To prepare a witness on anything about this contract, and certainly we're not going to prepare and present a witness who's going to interpret the written contract and give some kind of analysis, is overly broad, and it doesn't meet the rule requirements of particularity. Some of these others do, and we've agreed to present a witness. But this is a catch-all about anything I want to ask, they better be ready for it. How do I prepare a witness for that?
As it relates to the fill and the building envelope, right?
Yes, Your Honor, and I can add those words if it, but I
That would
just,
seem to That would seem to satisfy Dan, wouldn't it?
Correct, Your Honor.
Okay.
And just to be clear, Your Honor, I do think I'm entitled to question them on their understanding of what particular parts of the contract pertinent to those issues mean.
Under what basis? I mean, it's a written contract. It says what it says. That's for the lawyers and the court to determine.
Your Honor, they act in accordance with what they understand the contract to mean, so I think I'm entitled to
So
ask
give me
him.
an example of that.
I'm entitled to ask him what he thinks it means when they warrant that they're recommending a material, and what he thinks recommending a material means, because they're taking the position that they never recommended the material. Well, I'd like to know what their position is on that.
On whether they had an obligation to warrant the material?
Correct.
Or recommend the material?
To recommend the material and the warranty associated with that recommendation.
Whether we recommend the material
As one example.
is an issue of fact, which we keep going, is number
Well,
one.
so why can't she do fact discovery?
She's gonna ask a lay witness whether or not you satisfied this warranty obligation, or doesn't this warranty, or even a legal
Well,
argument what the
I
contract.
think she just said she's gonna ask whether it was your obligation to recommend or not recommend.
That's number one. We'll have a witness on that. But this, as written, number 6, is, you know, if we want to limit it to the fill and building envelope, that's okay. But to have a lay witness who's going to be interpreting contract provisions is not appropriate.
Well-
She could ask if we know or not we satisfied it, what we did. But that's what, I think she's made it clear what she wants to do.
I want to know what their understanding of that provision is, and others.
Well,
that
they either
relate
had
to
they either had an obligation to recommend, or they didn't have an obligation to recommend, right?
Well, I don't know, Your Honor, about the obligation, but
Under
what
the contract.
What the contract says is that if they recommend, then they must provide this warranty.
Okay.
Our position is, in fact, they recommended it, and they provided the
So
warranty.
your hope is to get somebody up there to interpret the contract and say, yeah, it was our obligation to recommend?
No, Your Honor, I want to ask them what they understood that provision to mean,
Okay, for what though?
because they're taking a specific interpretation of that. And so I want to know what the company's position is on that interpretation. I know what the lawyers say, I want to hear what the witness says.
That is the company's position.
What did you say?
Thanks, but I'd
What
like
the
to hear a
what the
witness
lawyer-
under oath cross-examined as to that position and not their lawyer.
So don't you want to find out from the fact witness whether AECOM recommended use of the shale? Isn't that the issue?
Yes, Your Honor.
So what difference if, where's the relevance of some guy saying, well, my understanding of this provision is that we were to recommend, or my understanding of this provision is we were not to recommend? What does it matter? The issue is whether they recommended or didn't recommend.
That's right, Your Honor, and there's a dispute about what recommending means. And so I think that I'm entitled to question him on what the company's understanding and position is
What
on
about
that.
what they actually did? What the fact that, establishing the fact, not establishing what their theory is of what this means or doesn't mean.
Yes, both, Your Honor. I
Well,
agree.
but why is one relevant? One is definitely relevant, one I'm not sure is relevant.
Well, Your Honor, here's how I understand their position to be based on what I've seen so far in the case and not having taken any depositions. Notwithstanding the fact that their project manager sent an email saying, you can use this material for this price that you
Okay?
are
So-
obligated to pay, that is not a recommendation.
Okay, so you're gonna depose that person, whoever wrote that email? And you're
I
gonna
am, Your
say-
Honor, but here's what I'm trying to avoid. They're gonna take the position, if it's convenient for them, that whatever he says doesn't bind the company because he's no longer an employee and he's
Well,
not
he
the
was at the
30B5.
time.
I understand.
Okay, so what does that matter that he's no longer?
Well,
You-
that's
you
why,
wouldn't- I mean, that would be a ridiculous position to take, wouldn't it?
Yes.
We're not responsible, even though he worked for us and said this,
Yes,
because he
Your
no longer works for us. That would be ridiculous,
Yes,
wouldn't
Your
it?
Honor, and again,
Okay.
Number one is knowledge of hazardous decision-making regarding suitability risk recommendation.
I know what number one says.
We're producing on
Okay,
that. That's
but-
the issue.
But you know who that person is that said you can use this material at this price to Great Lakes Crushing, right?
I know, Your
Because there's an
Honor,
email that says that.
I know based on that email. I don't know what communications happened internally at AECOM to get to that email where they recommended the use of that material.
Okay, so don't you ask the guy who wrote that email, why did you say this? Where do you get that information from? Well, I get it from this guy over here. Well, then I'll go depose this guy over here.
Yes, Your Honor, I understand, but again, the reason that we do 30B5 corporate rep depositions is because they're technically the only ones who can bind the company to those statements. So if I then present their former employee as saying something, they can say, well, that is not our corporate representative, he cannot bind us to that position.
Well,
Made worse by the fact that they clearly fired him because he messed up his project.
We're certainly not going to stand in front of a jury and say that, Your Honor, but we've agreed to produce that individual as well. But again, we're focused on the 30B5 and we'll produce someone who's going to basically parrot what he's going to say, if that's what they want.
Yeah, that's what
But
we want.
that, again, does not get into giving legal opinions on what a contract means, which is not relevant. That's for the lawyers in the court to determine.
I'm not asking anybody for their opinion in
Well,
this, I'm asking for their understanding,
Well, isn't that their opinion? Isn't it the understanding their opinion?
not necessarily.
Well, it certainly isn't a fact, is it?
It's a
This
fact.
thing means this.
It's a fact based on that individuals act based on their understanding
Well,
of things.
it's
And
their-
so I want to know what their
And-
understanding is.
And their understanding is going to be what's written on the paper, Your Honor.
Well, that's what you
Like,
say.
well-
He can say that,
Okay,
and
so
I can
who
cross-examine him.
would this person be? Who you imagine this person would be?
Your Honor, I don't know. It could be one of, I don't know how many people who worked on this project, were responsible for this project.
I think
Or
you-
somebody who wasn't, and that they
I-
educate and give them that
I certainly think you
information.
can depose somebody who has, with regard to the contract, as with regard to the contract issue of the fill in the envelope, their testimony on whether they complied with the terms of the contract or not.
Okay, so is the only issue then the word understanding? I'll take that out.
And if you, well, again, Your Honor, performance of the contract and breach, I mean, that is so broad. I mean,
What,
how do I?
I'm gonna go out on a limb here and say, if you produce somebody to talk about whether AECOM complied with the terms of the contract as it relates to the fill and the building envelope, they're gonna say, of course we did.
Most likely, Your Honor.
Well, and then what are you gonna say? Well, are you,
Again, Your Honor, I have agreed that adding the word, limiting it to the issues in this case, which are the fill and the building envelope issue, is sufficient from my perspective. And further, I will eliminate the word understanding.
Your Honor, number
If
7.
they want to just say, yeah, this is the contract and nothing more, I don't think that's acceptable.
Your Honor, number 17 is any warranty claims for or relating to any water infiltration issues and floor slab issues for the project as the subject of this lawsuit would agree to produce a witness. When they describe in particularity factual issues that they want a person on, you agree to produce them. But these general, just to have someone talk about your performance under the contract is not the required reasonable particularity that the rules require. Same thing with the contract. They have number 18, AECOM's contractual warranty obligations for the project is subject to lawsuit. We've agreed to produce. Okay, in the thousands, if not tens of thousands of pages of this contract, you now, with reasonable particularity, have told us what we have to prepare a witness on. We can do that. But these broad, just, catch-all, so I can play a gotcha game
Okay,
with
so
an
you-
unprepared witness aren't appropriate.
you have, of the 29, you have either 16 or 17 you've agreed to. right?
I believe that's correct.
You said 13 you don't, you said
That's
12 you
I
don't.
thought it was 12 when I counted.
Okay, so let's do it this way. Tell me the 12 you've agreed to.
Oh,
The
so it should be
17 that you've
we've
agreed to.
Sure. Here.
1, 4, 6, 7,
Well, I don't think 6, based on this
well, we
objection.
say, we had a qualifier, so, all right. So 8, 9, 10, 11, 12, 13, 15, 16, 17, 18, 20,
Okay.
22, 23, 25. I believe that's it.
And you have one more that you thought was agreed to?
No, Your Honor, I had mismarked it on my copy. I think that what Mr. Hayman said is accurate.
Okay, so 2 and 3 are out.
I think I also agreed to remove something else.
I think 5 was another,
5.
one of the national and global.
Yep.
Okay, so let's go to 14. Are you talking about written communication?
Any.
Huh?
I'm talking about any communications, Your Honor. Now, I understand nobody's going to know every conversation that anybody have. That's why the standard is whatever is reasonably available. But they're obligated to go and find out what communications there were that go beyond the scope of the documents. And if there's nothing available, then there's nothing available.
Your Honor, I don't know how we determine all representations that were made on this project at this point, other than written, which are going to be thousands, most likely. I've seen enough of them. And, you know, former employees who were prepared to present, and they can talk about what representations they made. But again, the breadth of this, I don't believe meets the requirement of the rule of reasonable particularity. If there were certain representations that you could identify for us that we could educate someone on, because that's what we have to do. Because the people who worked on this are no longer with the company, we can do that, but I don't know where to begin on this. I mean, do we give them, you know, tens of thousands of emails that have been produced in this case? Start going through, and I mean, it's unworkable. It's not reasonable particularity is required under the rules, and it's unduly burdensome. You know, again, the rules, not only 30B, but civil rules in general, does require that you weigh that. And if there's other means that do not, you know, require us to go through all of this, where you can depose the people who are on the project, you can ask them about their written communications, you can ask about their oral communications. But if you want us to educate a 30B5 witness on something as broad as this, it's a Herculean task, and we don't think it meets the balance that the rules require with respect to undue burden.
So you know who was working on this thing for AECOM, right? Working on this project?
I believe I know some of them.
Well, there was 4, you read them at the beginning of the
Were
day.
those the only 4 people from AECOM that were in the the capacity as the construction manager on this contract?
That's correct, Your Honor, and one of the third-party defendants, Green Space, had some individuals that were sub-consultant to us. And Plaintiff's counsel has asked for 2 of them, and we've said, yes, we'll produce those 2 former witnesses, or excuse me, former employees, who were the ones who were having these, as everybody knows from the records, these communications.
Okay, so you know you're going to depose those 4 people, I would assume.
I'm going to depose at least 2 of them presently. I haven't issued everybody who I'm going to depose, but Your Honor, I think the issue from our perspective is they're taking the position that is the owner's fault that this material went into the ground, among other things. And so I think I'm entitled to question a witness to get the company's knowledge of what you told the owner about this material.
The company knowledge is gone, Your Honor. We'll recreate it if we have to.
What do you mean the company knowledge is gone?
The employees who
She-
wrote the emails are no longer with us.
I know that. Okay, but
But we will educate someone to.
who were those individuals?
John.
No. What was their position within the?
John LaCagna was the project manager on South High School. This contract is for 3 schools. South High School is what we're here for. Dave Stahl was the project executive. Christy Wenzel, I believe, was an engineer who basically just is, documenting stuff. And the other person, I don't recall exactly, but the other 2 that they haven't asked for really were not that involved, the records show, but they're free to explore if they want with them.
Okay. So if, let's say that whoever the first guy is,
John LaCagna.
LaCagna. Let's
LaCagna,
say
I'm sorry.
LaCagna says, yeah, I told Great Lakes Crushing to put that shitty shale in the ground. Okay, does that not bind the company? Is that your position?
Oh, Your Honor, if they want to say that if they want to agree that all of Mr. Landocino's statements bind the company, that's acceptable to me.
And if that, why wouldn't they bind the company
Well, I think, Your Honor,
as a construction?
as far as binding the company, the 30B5 deposition is you're entitled to introduce it at trial as evidence, regardless of any witness availability. So that's what it is, which is why we have a lot of these things like legal understanding. This is a game of gotcha. Quite frankly, most of the stuff should be interrogatories or RFAs, but they're not, and they want us to put up a witness who's going to slip up and say, yeah, we agree that's what that contract interpretation means, and say, we've now bound the company and we're going to read that to the jury. It's all fine and good, Your Honor, but we have the right to insist that they meet the rules, which is why the rule requires reasonable particularity, because of the uniqueness of a 30B5 and the obligation for us to prepare someone and the fact that it's admissible evidence. We have the right and opportunity, number one, to insist that they have reasonable particularity balanced with undue burden and hardship, especially when there's other ways to get this evidence. Whether or not Mr. LaCagna binds the testimony, his testimony is what it is. He's going to either say the same thing at trial or they're going to impeach him. So, again, there needs to be reasonable particularity so we can produce a witness. Now, normally, Your Honor, we'd have fact depositions, and when our 30B5 occurred, and they said, we want the representations, we're going to say, our witness is going to say, read Mr. LaCagna's deposition, pages 50 to 80. But they want this to go first, fine, but that's going to put a burden on us, and we need reasonable particularity so we can produce someone else to say, good job.
All right, go to 19. Okay, so claims are made when things start going wrong. Is there a record of who at AECOM investigated any warranty claims?
There is, Your Honor.
Who's that?
It's primarily Mr. Lakenia and Mr. Stahl, and in conjunction with the green space construction management people. But again, this is I believe, I have the year right, the school was completed in 2019. These issues, at least formally, were presented to us, I think, in 2021. If I have, almost 2 years after the building was open. Mr. Stahl, at least Mr. Stahl, I don't remember Mr. Lakenia, I believe he did too, re-engaged.
Were they gone at that point?
No,
The
they were
company?
not, Your Honor. They left shortly thereafter. We responded. There's other provisions in here where they say all notices and response to notice. We said, fine, and we'll produce someone on that, But the investigation was those two individuals who, of course, they can depose them. They left both left in early 2022. So at that point, it was basically lawyers. Green Space, I believe, still had someone who was involved. They were meeting regularly with the architect, with the school. The architect was doing a whole bunch of analysis. They were doing floor scans and all this stuff. This went on for years, basically, or at least 2 years, where the architect was driving that train and deciding what to do and they hired a consultant to do investigation, et cetera. So, after 2022, when Mr. Lakenia and Mr. Stahl left, AECOM did have an individual who had nothing, when they requested a meeting, they had an individual who had nothing to do with the project and he would go out, but then it really became the lawyers and their experts, so it's really getting into, but again, it's not like we had an investigation over a weekend. It is an incredibly broad topic with incredible breadth that went on for years before this lawsuit was filed.
Okay, so do you know who investigated these warranty claims?
I know Mr.
Lakenia?
Lakenia and Mr. Stahl was involved. I don't know Mr. Gotham, apparently, but I don't know beyond that. But again, Your Honor, I don't know why I wouldn't be able to ask about how they investigated the warranty claims that they breached. Because and if he wants to say only Mr. Stahl and Mr. Lanokina know, that's fine. But then he should agree that their deposition testimony binds the company. And it's not overbroad, because if your position is that these are the only two guys that were involved, well, guess what? They can talk to whoever you want from the company, get their knowledge and understanding, and then testify on behalf of the company. It's not broad. That's what the case is about.
If Your Honor, if I may, if we were to do this like most of these proceed, and we had these categories, and we're going to take Mr. Lakenia's deposition, and this is very typical and unusual, you'd say, okay, we're going to now do Mr. Lakenia's individual deposition, and we're going to now, but he's now going to be on categories 4 and 5. You can now depose him as a 30B5 witness. They won't do that because they want us to have a 30B5 before we do Mr. Lakenia. Am I going to get Mr. Lakenia to sit for 2 depositions? I'll be, hard enough to get him to sit for 1, scheduling time off his job. So let's do them together if that's the case. It may very well that we can get him to be one of these, but we can't, if we want to insist on a 30B5 first, it's a problem. I mean, the 3 individuals that plaintiff said investigated are 3 individuals that have asked for their deposition. We'll get to Mr. Godham in a minute, but we've agreed to produce them, but we have a clear understanding and ask the court's guidance for some of the various reasons we've talked about, global knowledge, et cetera. But they'll have the opportunity to depose those 3 people. But if they want a 30B5 on something this broad, it is going to take a long time to educate someone on that, rather than just ask the people who actually did it.
All right, 21. that the same, it's the same as 19 except for floor slab?
It's the same objection, Your Honor, but that's correct. It's basically, again, I'm talking about thousands of representations, probably.
All right, 24, go to 24.
Similar objection, Your Honor. We don't believe this is with reasonable particularity. You know, they've got all, whatever written internal communications there are, but again, you know, we're talking about hundreds of thousands of emails that have been produced in this case. And this is a very broad word that makes it difficult, if not impossible, to prepare a 30B5 witness, as opposed to deposing the people who are actually writing the communications.
Your Honor, if I might, it seems like what Mr. Haymond is saying is that if there are individuals who are involved, then companies are not obligated to produce witnesses pursuant to 30B5 notices. If that is in fact the law, then please cite that to me so that I can, you know, consider it, and will, you know, remove my thing. But that is absolutely not the law. There are individual fact witnesses and there are corporate representatives. Only corporate representatives bind the company. Again, if he wants to take the position that those individuals are their corporate representatives, that's fine. He can pick whoever he wants. It seems to me that relieving the burden that he's talking about is to use those people as his representative. Then he should just do that. He can pick whoever he wants, whether they work there or don't work there. It doesn't matter.
Even if I pick a Mr. Lakina or Mr. Stahl, or probably be, some of these categories would be several people, you know, they're going to be our 30B5. Now I got to have them prepared for more than just what they know. Fine. We have not taken the position that they're not entitled to take a 30B5. We have taken the position that they got to meet the rule requirement that you specify with reasonable particularity so we can produce a witness. I think we've already seen, Judge, this 30B5, the way with the scope that they're envisioning, is going to take a week. I mean, there is undue burden and hardship to be balanced where you cannot say, produce a 30B5 witness to answer anything I want to ask in this case. That's not the rule. And that's what they're trying to do with all of these broad categories. And as you see, just so they're sure, they just keep repeating a lot of them in different forms, so that in essence they have us educate a witness who can talk about anything to do with the case. That's not a proper 30B5 purpose.
All right, so you have around 26 through 29 that are in dispute, correct?
Correct, Your Honor.
Okay. So I'll consider those that are still in dispute and rule on those. Okay. Now what
Okay,
about
thank
this?
Thank you, Your Honor.
This guy that this Gautam. What about Gautam?
We've agreed to produce him, Your Honor, for deposition. As I told plaintiff's counsel, I believe he's going to say, I have no recollection of ever working on this project or discussing with them during the project. That's fine if they want to do that. You know, there's about 6 in the sea of thousands. There's, I don't know, 5 or 6 emails where they're trying to schedule a meeting with him. But that's it. There's no record that it ever occurred or that it ever did it. But nonetheless, that's fine. They can depose him on that. But they've made it clear in their submissions to the court, but what they want to do is turn him into a geotechnical expert and start asking him all of his opinions about geotechnical items with respect to shale fill, which is irrelevant to whether or not we met the spec. And they're trying to turn him into a expert witness who's not been designated as such. And they know, because I've been out there with Christine and Mr. Gautam on at least 2 occasions, that after the lawsuit was filed, we as attorneys have used him as a consulting expert, which is absolutely privileged under the rules of work product. So, you know, we will not let him testify to any of that privileged material. But if they want to take his deposition and hear him say, you know, and who knows, and maybe they'll throw something from him or he'll recall something, but to say that he doesn't have any recollection work on the project, we'll produce some. But we're not going to let them get expert opinions out of him, which again are not relevant to whether or not we met the specification. We were not the geotechnical engineer on this project.
Your Honor, I don't intend to depose him to seek his opinion. I want to know what he knows about this type of material and its use in similar applications.
How is
Why-
that?
And I'm not even gonna take the position that what he says is true or not.
But
But I wanna
so
know.
what does it matter what he thinks, what does it matter what he thinks is shale in these kind of projects? He either had some input on it, or he didn't.
Yeah, Your Honor, I think one of the reasons why it is very relevant is because, again, if they have institutional knowledge of these things, they represent and market themselves as bringing that institutional knowledge to all of their products, and in this specific case, made that representation to the client, it matters. And it matters because there's a consequential damages waiver in this contract, except if they acted with gross negligence or willful misconduct. And so if they're talking to a guy who knows something about this material and why it shouldn't be used, and he either didn't tell them or told them something that was accurate or told them something inaccurate, and they proceeded to use all of that stuff anyway, it goes to the issue of their gross negligence and willful misconduct.
Okay. Well, I guess what you're gonna have to do is tell me when you do your deposition at Gowden, okay? And I'll sit at my desk and stare at my phone and wait for it to ring,
Okay.
okay?
I don't intend, Your Honor, to ask him anything about work he's done, the Thompson Hine firm, anything he's communicated with them, or anything they've communicated with the dozens of in-house counsel they have on this case.
I'm just, I'm struggling to find out how, what he says other than as it relates to this project is relevant. But you can ask it, you can object, and then you can call me when you can't agree.
Thank you, Your Honor.
Okay, what about this ordering and scheduling? The first attempt to schedule depositions was December, mid-December?
Yes, Your Honor.
I guess the first question is, why is that?
Your Honor, from the plaintiff's perspective, it was a large and substantial task for everyone to gather and produce the extraordinarily large quantity of documents in this case.
Okay.
It was a very big task for the parties to, or at least again speaking from the plaintiff's perspective, to get their experts' reports completed. And then, Your Honor, at least the plaintiff spent a substantial amount of time preparing for the mediation, which
I bet that went over like a lead balloon between the parties, right?
not even
It was not successful, Your Honor. And
Sounds like it was a disaster.
yes.
What did it last, like
it's
5 minutes?
It's always a
No.
disaster if it's not successful, Your Honor.
You know, well, sometimes it's
It was
successful
2
and
days.
the parties narrow some issues and get closer together so that it can work eventually.
It was 2 days. And if I could just speak to that, a couple of issues. Document production has been an issue, and we've been trying to work with plaintiff's counsel on that with their production for a long time now. We had 40,000, I think, additional emails from the YMCA produced in November, right before the mediation. I think just this week, based on our meeting first to try to get the school district, because there's some glaring deficiencies, we got another roughly 30,000. So that's not been done. I've also been trying to get verified interrogatory responses on things as simple as itemized damages, which we don't have yet. But I do believe that the mediation, we didn't get the expert report until June. We didn't get the building envelope expert report until September. The parties did spend, I think, substantial time selecting a mediator during 2025 and scheduling it. I think we had our first call with him in August. There was a lot of meetings, and at the very first meeting with the mediator, there was a discussion about what do we need to do to get this case ready for a meaningful mediation. And there was a discussion about, do we do a bunch of depositions, or do we do things like get some expert reports in the mediation setting, because they're not due yet, but we still don't have the third-party defendant expert reports. so that we could do that. So all the parties, I think, did focus on the mediation, at least the latter part, once the plaintiff's expert reports were in September on that process. So I do think that that was a conscious decision that I can't speak for everyone, but that the parties collectively made was the best use of our time at that
I
point.
agree.
Okay. So besides your 30B5 and the individual, how many other individuals do you anticipate deposing?
Your Honor, thus far, I have noticed, I believe, 3 individuals, 2 former AECOM employees. I believe the project manager for Great Lakes Crushing, which was the site contractor that brought in and used the fill, as well as the 30B5 of Great Lakes Crushing. Quite frankly, I was waiting to see what information I got there and where else that was going to point me. Mr. Heyman has requested the deposition of Jeff Henderson from TDA.
So you've indicated about 6 different people right now, right?
Presently, yes, that I have noticed.
Okay. Dan?
I believe we've asked for 8, and I've actually, because the party's not here, ATC's not in the case, but I've reached out to their counsel and asked for one of their employees. And quite frankly, Your Honor, I mean, mine include their experts, which is another issue I think that not just me but other parties want to discuss is the case schedule. And if we have a February report deadline, a March 1 summary judgment deadline, which we currently have, is why I asked for their experts. If there's a change to that, I mean, the experts can obviously wait. But those are the ones that I
So
determined are essential,
9 or so?
that I would like to have at least before dispositive motions due. There's going to be a few more. I mean, I think the other parties, there'll probably be another dozen at least, I would think.
Okay.
Any other parties have feelings on that?
George?
Well,
You've been very patient.
representing the architect TDA, Mr. Heyman has noticed the deposition of main architect of TDA on this project. Christine did not notice any. So what TDA intends to do for depositions would really depend upon what's going on with plaintiff and AECOM. But I mean, we produced an expert on behalf of TDA. ATC is not in the case, but is I'm in communication with ATC and wants to take somebody from ATC. That's the much as I can tell you as to our plans on deposition.
Megan, do you have anything you can give me? Okay, Frank? Steve? Okay, so what kind of time frame are you all looking at collectively for just the fact that not the expert? You guys want you guys want to schedule expansion, so
Frankly, the difficult we've had, and I'm not saying it's anyone's fault, with the number of council parties, we just try to schedule mediation centers, try to schedule meetings. I almost feel like we need to designate what I suggested when I asked for a meeting for last week with everyone about let's start talking about how we're going to schedule this. What I suggested is let's do it based on what is council availability. Christine's position on the order side, and that wasn't acceptable to the plaintiff, and it became readily apparent that just doing that's going to be an incredible challenge. And I almost feel like this is one of those cases where we need to designate a couple weeks of the month that says so that we're not running in now, so we're not running into council saying, well, I got a conflict everywhere. These weeks is what is available, we're going to do them. So we can progress this. But I would think that fact depositions alone, and by the way, our 9, I don't believe is going to be complete. That, again, was the
So there's this, those are the procedural issues that I think you should.
When am I getting a response on the bifurcation?
Plaintiff is going to object to that, and I intend to file that by the opposition deadline date of Tuesday. What they're asking for is to make the plaintiff
general damages, and they're not on there.
haven't even looked at it yet, so I don't know if it was filed. What was your position in mediation on this?
So, Your Honor,